Welcome everyone. My name is Elizabeth Beattie. I'm a partner at Harrison Clark Rickaby's and head of the in-house lawyer services. Thank you for joining us today for the next in our series of in-house question and answer sessions. This month we're focusing on whether your insurance policies are fit for purpose. Just before we start and before I introduce my colleagues today, a little bit of housekeeping. This is a Zoom webinar that's being recorded. It's intended to be an interactive session, so what we'll have is a short presentation from my colleagues and then it'll be over to you for questions or comments. The key thing for us today is that this is part of what we offer as added value for our in-house lawyer contacts. It's designed to be relaxed and allow you to pick the brains of our experts. If you aren't comfortable asking questions on camera, you can use the typed chat facility at the bottom of your screen. So what I shall do now is I shall hand you over to my colleagues. Today we've got partner Jonathan Edwards and solicitor Rhiannon Willimont, who are from our insurance risk and regulatory team. It's quite a mouthful to say that, I have to say, but our key experts who work extensively with in-house lawyers. So I shall hand over to you, Jonathan, first, if I may.
Thank you, Elizabeth, and good afternoon, everybody. I hope you'll find this informative. And just to reiterate what Elizabeth said, if you have any questions at all, please just ask as we go along. To begin with, I just want to emphasize how important it is to properly understand, as we say on this slide, what keeps you up at night. What are the key risks to your business, and what are the likely outcomes if any one of them was to occur? That's the identification, and that's a lot harder than it seems. But it's really important to understand that in order to properly understand the insurance that you may need to buy in order to mitigate should one of those key events actually occur. And then once you have that insurance product, how can you be sure that in the event that a key risk manifests, how can you be sure that it will actually respond in the way you want it to and indemnify against the losses that are likely to be incurred? And I think we saw through COVID and particularly the subsequent business interruption insurance claims, just how much confidence consumers have lost in the insurance market. And certainly we have been requested more and more to look at organizations' policies and do a review and to provide them with some security around what it is they've actually bought and whether or not it will actually respond when they need it to in the most crucial moment. If the insurance industry is going to recover the trust that I believe it lost during COVID or after COVID, it cannot simply hang customers out to dry on a technicality. And without trust, what are customers actually, how can they be confident that what they're paying for is actually of any real value? I think also one of the areas that insurers would do well to review is transparency over its pricing. Customers want to understand the basis on which their risks are actually being written, because then they have the opportunity to consider and implement any risk mitigation strategies, which might then reduce the premium they're being asked to pay. And that's actually harder than it seems, or harder than it really should be, to get that information. So I think that important factors insurers would do well to heed is thinking about what matters most to its policyholder. It certainly talks a good game before you buy your insurance product, but does it actually deliver it when you need it? And are you getting the best value? Is there sufficient transparency? And always one area of contention is around claims, because policyholders want to have more say. So when a claim arises under the policy, insurers will deal with that claim on behalf of the policyholder, and more often than not, deal with it in a way that is expedient rather than in a way that perhaps you, the policyholder, might like to see that claim dealt with, because you fear there may be repercussions. It may open floodgates, for instance. And policyholders want to generally feel that insurers are working with them closely, so that should the worst happen, they're able to get back up and running as quickly as possible. So just a few thoughts, general thoughts, which I hope are useful. So now, Rhiannon.
Okay, thank you. Can I have the next slide, please? Thank you. So this section here is kind of, once you've identified your key risks, these are some of the things you need to look out for to make sure that you're actually covered. So the first thing that you should do is you should actually review your existing policies to understand exactly what it is that you're covered for, and whether there are any exclusions or conditions that might apply to your cover. And it's really easy to overlook any exclusions or conditions, which actually could leave your business vulnerable and uninsured. So we've recently seen an increasing number of policies where the main risks to businesses are actually excluded, and businesses were left in a very vulnerable position. So we've identified 3 top exclusions or conditions that you should look out for when reviewing or negotiating your insurance contracts. So these are the identity of the insured party, whether there are any territorial limits, and whether any conditions might apply to any extensions under your policy. So these are just some examples that we've come across recently, which we thought might be useful for you to kind of understand the importance of looking at these conditions and exclusions. So a group recently approached us to do a policy review because they wanted to launch a new product. And so the structure of this group was that there was a parent company and various subsidiaries, and all of the business was actually conducted through the subsidiaries. So while we reviewed the policies and we noted that they actually had a really comprehensive suite of policies in place, the insured party was the parent company rather than the subsidiaries. And actually the subsidiaries were not covered at all. And so this is actually a massive risk to the group, because all of the businesses was actually conducted through the subsidiaries. That meant that any claims arising out of their products would not have been covered by any of their insurance policies. And so the next kind of condition or exclusion we thought is really important to look out for are territorial limits. So we were recently approached to conduct a policy review for a client, and we discovered that they were covered to send out engineers across the UK, but they had recently expanded their business and they were now sending out engineers across the EU. And while this was a really important, great step for their business, their insurance contract actually specifically excluded any claims arising out of any occurrences within EU territories. And this meant that a significant proportion of their business was actually left uninsured. And the final point to consider is whether any conditions might apply to extensions under your policy. So in an insurance policy, extensions provide additional cover for specific circumstances. And this can be really, really beneficial and offer an additional peace of mind. But it's really important to identify whether any conditions attached to that extension. So a recent case where this came up was where we were asked to advise whether our client's insurance policy provided cover in respect of a civil commercial contract claim. So our client's policy included a contractual extension which indemnified them for any claims arising out of commercial contracts and any associated legal costs. And at first glance, it seemed our client's contractual liability would be covered and any legal costs would also be met. However, the contractual extension clause also contained a condition that our client was not actually aware of. The insurer would only provide cover if the client had notified the insurer prior to entering into that contract of the particulars of the contract, and the insurer had confirmed in writing that that specific contract would be covered under the extension. In this case, unfortunately, because our client was not aware of the condition attaching to this extension, their commercial claim was not covered under the contractual extension, and they're having to meet the liability arising from this claim themselves rather from their policy. So I'm now going to pass over to Jonathan for the next part of this presentation.
Thank you, Rhiannon. If there are any questions, please don't forget to ask as we go along. So now we move on to that important document, Statement of Fact, and the duty of fair presentation, which you are very familiar with, a concept brought in by the Insurance Act. So what is a statement of fact? Well, put very simply, it's a form outlining all the information given to an insurer that is signed by the policy holder. And that information is really important because basically it is the basis on which insurers will A, assess whether it is a risk that they want to write, B, what price they are prepared to write the risk at, and the terms and conditions they will impose on writing that particular risk. So a policyholder is required to give fair presentation. And essentially what that entails is disclosing every material circumstance which the policyholder knows or ought to know, or sufficient information to alert insurers that it needs to make further inquiries, that it makes that disclosure in a clear and accessible manner, and that any material representation as to a particular fact is substantially correct, and where there is any matter of belief that that is made in good faith. So what is material? Well, material is essentially a fact that would influence insurers' judgment as a prudent insurer in deciding whether or not he intends to write the risk, and as I said before, on what terms. Failing to make fair presentation of the risk could either invalidate your insurance or alternatively affect the extent of cover. So my advice is always, if there is any doubt, it is better to disclose. And always keep a copy of any information that you provide, because if there comes a point where an issue arises on disclosure, we will need to look very carefully at what information was actually provided. We had a case very recently, a very sad case involving a married couple. The husband committed suicide and he had mental health issues. They took out a policy of life assurance with a well-known insurer and completed the statement of fact. Unfortunately, when he completed the statement of fact, he failed to disclose the fact that he had any mental health issues. In fact, he he actually answered the questions no, rather than yes. And after his death, a claim was made and, you would say not surprisingly, rejected. However, what happens in this situation is that insurers have to reconsider the risk and as to whether or not they would write the risk on the basis that the questions had been answered correctly. In other words, in this particular case, that he had answered properly, that he had a history of mental health issues. Rhiannon did some fantastic detective work and scoured the media and found statements made not long before the couple took out the policy of life assurance, which basically said that this insurance company, and these were statements made in the public domain by the chief underwriter, that they would give serious consideration to writing risks where people had a history of mental health issues, and even in what we argue cases that were more severe, if you like, than this particular person had. And we argued that given those public utterances, not only had he, even if he'd answered the questions correctly, the insurance company concerned would have provided cover and would have provided cover on a standard basis, that the issues were not so severe that they would have written the risk, but on the basis of an increased premium. Now, if they came back and said, well, all right, we accept that we probably would have written the risk, but we would have charged a much higher premium, that increased premium is simply deducted from the claims payment. So, for instance, if the increased premium amounted to £10,000 and the payout was £400,000, the payout would be £390,000. So that gives you an idea as to exactly how important it is to make proper disclosure. But in the event that proper disclosure hasn't been made, that is by far not the end of the story. Rhiannon.
Thank you. So I'm now going to talk about condition precedents. And if I could have the next slide, please. Thank you very much. So insurance policies generally contain condition precedents, and these are often onerous, but it's really important to comply with them, because if you don't comply with a condition precedent, your insurer might be entitled to decline cover in respect of a specific claim, or they might actually be able to avoid the policy altogether. So there are two types of condition precedents, which I will take you through today. So there's condition precedents to risk and condition precedents to liability. And so if a condition precedent to risk is not complied with, the insurer never comes on risk, and the insurance contract will be treated as never having come into existence. And aside from this having serious implications to any claims that might be made, the fact that the policy is treated as never having come into existence could also have a knock-on effect to any contracts held by your business that require an insurance policy to be put in place. And so common examples of condition precedents to risk are the condition to pay insurance premium, and also a condition that the information you provide before the policy commences in relation to any known losses is correct. And so those are the condition precedents as to risk. And then condition precedents as to liability are often, they can be much wider in scope, and they are actually often a lot more onerous. So a typical example is a claims condition, which dictates when and how a claim or a potential claim must be notified to the insurer. These can often easily be overlooked, as when you become aware of a claim, it's really easy to focus on investigating the merits of a claim, engaging legal representation, and also dealing with any implications arising from that claim within your business or within your client contacts. And so this means notifications to insurers can sometimes be made too late, or they can be made to the wrong person. And because this is considered a condition precedent, failure to comply with it means that the insurer is entitled to avoid cover for that claim. And it runs the risk that you're left without any cover at all for that claim. So it's really, really important to look through your policy and be able to identify which conditions are actually condition precedents, and exactly how and when you need to comply with them to make sure that you maintain your cover for any potential claims. I'll now pass back to Jonathan. Thank you.
Alteration of risk. Now, obviously, during the course of a policy, Tom, change the slide, please. During the course of a policy period, circumstances may change that change the nature of the risk that your insurer originally agreed to cover. So any change or alteration which would materially affect the risk of injury, damage, or indeed liability would need to be notified. There is an ongoing duty of disclosure to insurers concerning material facts and indeed fair presentation. So if anything changes about the way you conduct your business, think about the implications of that. Think about whether it changes the nature of the risk that's been insured. And again, if you are in any doubt, you should approach insurers, have a discussion with them to see whether or not they agree. And you always want to get their written confirmation that hopefully, no, it's fine. Will be covered. Or maybe they will say, well, it does change the risk and therefore we will charge an additional premium, or it may affect their risk appetite completely. But it's better to find out these things when they actually happen rather than what tends to happen. A claim is made, presented, and insurers turn around and say, no, this wasn't covered, you didn't notify. So better to be cautious, because you may find yourself without cover and exposed to a considerable financial sum. There's quite an interesting case. It's called Azari and New India Assurance. It goes back to 2009 and basically says that when looking at alteration of risk, the factors that need to be considered are that the alteration and change must be more than temporary, and it must effectively make the risk a new one, and that you, the policyholder, must actually be aware of the alteration or change so that you were able to notify insurers. But it's something that people in our experience tend not to think about as much as they should. So no matter how big or small, I think it's important to assess the potential impact and then to notify just to see whether or not you've got the cover that you need. Rhiannon.
Thank you. So we talked about exclusions really briefly earlier. Could I have the next slide, please? Thank you. So yeah, we briefly touched on exclusions earlier, and I wanted to go into it a little bit more depth now. So exclusions will your insurance policy will have general wording and then specific wording set out in the schedule. So to kind of define the scope of the policy, you need to look at both your policy wording and the schedule, which sets out exactly which terms are included and which exclusions will apply. And this will be specific to you. And every time you renew, there might be different exclusions contained in your policy. So you need to constantly have an eye on what's excluded, and you need to be aware of any potential risks that might arise from this. So exclusions can cover a wide variety of events. So they could range from, for example, war exclusions, which exclude any claims arising from acts of war. Or you can have specific property damage exclusions, which could exclude any damage arising out of pollution or contamination. And so they're very varied and a huge breadth of exclusions. So it's really it's really important to carefully review your policy to see exactly which exclusions apply. And when negotiating your insurance contract, you need to have a really solid understanding of the main risks to your business, so that you can assess whether any specific exclusions are reasonable for you or not. So one example might be a business located next to a factory which processes contaminants such as heavy metals or chemicals will be less likely to accept a property damage exclusion for damage caused by contamination than a business which is located on a quiet high street next to a clothing retailer, for example. So ultimately, whether an exclusion is acceptable to you or not will depend on the specific risks for your business and also your appetite for risk. And this is a very important consideration when you first take out your policy and every time you get a renewal quote as well. And I'll pass back to Jonathan. Thank you.
Next slide, Tom. Okay, look, brokers, a bit of a hobby horse of mine. One common theme that's been coming out of these reviews is that brokers have perhaps not immersed themselves in their clients' business as much as they might, to properly understand exactly what cover their client actually needs. And we've seen many examples of where brokers have simply sold standard, what I call off-the-shelf policies. And more often than not, we find that the policies themselves, so far as the client's business is concerned, is not fit for purpose. And had they taken a bit more interest in understanding exactly how the client operates, exactly what their concerns, risks were, then it may well be that they would have looked at a different type of cover, or at the very least made sure that those key risks were properly covered. And I'm not saying that's a problem with all brokers, but it certainly is with some. And there is a lot of trust placed in brokers by clients, and why not? They are the specialist, and so you rely on them to make sure that they provide you with the cover you need, so that in the worst of events, the cover is there, and there is an indemnity which will mitigate against the losses that are incurred. But this, unfortunately, is not always the case. And there was that example of where we found operating companies hadn't actually been insured. Just be mindful. I always worry about the conflict of interest to some extent, because the broker makes his money by selling insurance and is paid by the insurer via commission. There is that potential for conflict of interest. Obviously, it is in the broker's interest to sell insurance. And there have certainly been a number of occasions where we've been left scratching our head as to why a particular client has clearly far too much insurance than they actually need. So I would just be mindful and certainly rather than accept what a broker is telling you, is to really sit down and test their advice and challenge to make sure that you are completely satisfied, that you understand exactly how the policy they have acquired for you actually works in practice, and to point out any likely shortcomings that may have a significant impact, and how best they might be remedied. So just a word to the wise, really. Don't always take things, and I'm sure you don't take things at face value. Just make sure that you are happy, that you can, going back to where we started, sleep at night, because you are confident that the policies you have in place will respond when you need them most of all. And then next slide. I just want to say something about indemnity limits, because this is always quite problematic. An indemnity limit is the maximum amount that an insurer will pay under a particular policy during the policy period. And I found some interesting statistics, recent statistics, which suggest that 21% of businesses have reduced or are considering reducing their insurance cover over the last 12 months. Obviously, if they were to do that, potentially exposing them to increased financial risks. But it's not massively surprising, given the economic climate at the moment, that businesses would look to cut costs where they possibly can. 50% of UK businesses are said to be underinsured, and 40% of policies which have a building component to them are suspected to be uninsured by at least 20%. And in relation to underinsurance, that can lead to policy avoidance, cancellation, or only partially paid claims. So in relation to underinsurance, where that happens, it may well be that you will end up having to pay a proportion of what you thought was covered. So it's really important to make sure that when you're buying property insurance, that you are getting correct valuations. Now, some policies, they have room for maneuver. So some will say that providing it's within sort of 75%, they won't take note. But some insurers will, and it can have profound consequences. Some cases we've found that there's too much insurance, as I mentioned before. There was a case recently we were looking at, which was an organisation that was carrying excess employers' liability cover up to £40 million. So this was a primary layer of 20, and an excess of 20. Now, as I'm sure you all probably know, the standard EL cover is around £10 million. And this organisation had, in fact, when I looked at the claims experience, in the last 5 years, had 2-3 claims amounting in total to about £1,200. So on that basis alone, you would think that £40 million worth of EL cover was somewhat excessive and expensive. So I think it's really important to look at indemnity limits, and I would suggest that there really is no need to exceed standard limits unless there is some very, very good reason for it. Next slide. And policy reviews, I think this should be continuous. As I said before, every time you feel there may be any alteration in risk, that would certainly be a moment to look at your cover to satisfy yourself that the cover is unaffected, or if not, obviously then to approach insurers accordingly. But it's something you need to keep under review. And for instance, valuations, there may be changes in valuations. You want to make sure that they're kept up to date and current. And I would certainly suggest that policy reviews annually are an exceedingly good idea. Good. That covers all we really wanted to say this lunchtime. And any questions?
Thank you very much, Jonathan, Rhiannon. It's really, really thorough and comprehensive comments today. I've got one question that we've received so far. There's several others actually that are coming through, but first one for you is, if insurers use external panel for coverage advice, is the policyholder entitled to see the advice if the cover is declined?
No, I don't think so, is the answer to that particular question, because that is a matter between the insurer and its legal advisor. Obviously, if they are declining cover, insurers should inform the policyholder on the basis on which they maintain that cover doesn't apply. And then it is a matter then for the policyholder to decide whether the reasons given are meritorious or not. And if not, they should seek their own advice to see whether or not they can mount any challenge to insurers' declinature. So the advice would, between insurer and lawyer, be privileged, but there's nothing to prevent insurers waiving privilege and offering to share that advice in good faith. So particularly if it's a policyholder who is valued, and I suspect they're more likely to do that if the policyholder is valued and pays a large premium, rather than one who perhaps doesn't pay such a large premium, but that's the cynic in me. So yes, that's basically what the position is.
Thank you very much. Another interesting question has come up is that our group often acquires new businesses which sit as subsidiaries under the parent company. Is there a way to ensure that new acquisitions are covered under the policies without notifying our insurer each time?
Yes, because many policy covers cover what I call the subsidiary clause. So that any subsidiaries that cover is automatically extended to any subsidiaries existing or purchased during the period of policy cover. The only thing is, it really depends what this subsidiary does. So if the subsidiary does other activities that change the nature of the risk that have been insured, then you should make a notification so that insurers understand what it is that subsidiary does, and then will sort of review the risk and their rating of the risk. If there is a standard subsidiary attachment within the terms of the policy, and it's not always the case, so don't assume it is, because when we were talking about that particular company where it's operating companies that weren't covered, the first thing we looked for was the subsidiary clause, and it wasn't there, which meant that only the insured actually named in the schedule was covered. So that had to be, immediately addressed. But if it's there and the subsidiaries essentially carrying on the same sort of activity as the parent or other subsidiaries, and it falls within the sort of the nature of the business that's actually being insured, then no, there's no need to notify each and every.
That's great, thank you. A few more before we wrap up for today. This is a practical question. How can I know if the policy limits suggested by insurers are reasonable?
Well, as I said, I think the starting point is standard cover. And for EL, as I said, standard cover would be 10 million. And I think you really don't need to be exceeding that unless you have some very real concerns. And looking at your claims experience will almost invariably give you a clue. What I would say is particularly with sort of casualty type policies, they are sort of claims made policies. So they only respond to a claim when the claim is made rather when the incident occurred. So you could find that you could have an excellent track record, excellent claims experience, and think, well, I don't need to be carrying as much as 10 million. I could probably live with, say, 5 million. And then a claim suddenly appears, and it's a very significant claim. And of course, you've changed the limit so that the limit when the claim is notified is less than it was when the incident occurred, then potentially you could leave yourself exposed. It's a matter of judgment at the end of the day. Nobody wants to be paying more insurance than they absolutely have to. But again, going back to where we began, you want to be able to sleep at night and feel confident that you've got the right level of cover in place.
That's great, thank you very much. Now, if we just, if we could revisit something we talked about earlier was the statement of fact. And I think you should have touched on this already, but it might be helpful just to go over it again. Is that if you provide incorrect information on the statement of fact, I think before we were talking about perhaps insufficient, but whether actually it's incorrect, is the policy automatically void? No, and for the reasons I explained when I talked about that sad case with the man and his mental health issues, that the situation is that insurers have to review the risk on the basis that the information was correct. And they will either conclude that had that information been available to them when they consider the risk, that they either would have not insured, not offered cover, or they would have offered cover, but at an increased premium, or it made no difference, they would have offered cover, but on the usual standard terms. Have you, in your experience, out of interest, have you ever dealt with it where they've sort of it has been made void? They haven't taken that the view that you've just mentioned, that they have actually found a legitimate basis upon which to make it void? We might have one any moment now. Where I think we have very strong grounds for arguing that
insurers would have covered, but we are waiting to hear from them. They declined originally. We made very strong representations. They've been reconsidering and reconsidering, and we are just waiting to hear what the outcome will be. It could actually have very profound, if they were to continue to decline and we were to take it to court and we were successful, it could have profound implications for them, not only in relation to this claim, but in relation to a lot of other claims that they have probably declined, which they would then have to revisit. And the sum would far and away exceed whatever settlement they were prepared to offer our client.
Right, well, that's really useful to know. Thank you. I think we've got time for one more question. It's to do with, if we fail to comply with a condition for an extension, is there any way we can still claim under our policy?
Rhiannon, go on, you can have a go at that one.
Okay, so it would depend on whether or not, going back to the condition precedents, whether the condition is actually just a general condition or whether it's a condition precedent. And that all depends on how it's drafted. And so in order for it to be a condition precedent, it has to be really clear that it is a condition precedent. And it also has to really clearly set out the consequences of non-compliance. And so if there's any ambiguity, it will actually be construed against the insurer. And so if there's any ambiguity, or if it's just classed as a general condition and you failed to comply with that in relation to an extension clause, in order for the insurer to then avoid any cover, they would have to prove prejudice. So they would have to establish that because that they've been prejudiced by you failing to comply with that condition. So it all depends on how it's drafted and also on the facts of exactly what the condition was and what the breach was and how you handled it. So it's not the end of the road, and there is a possibility that you might be able to still be indemnified under that clause.
That's really helpful. Thank you very much. I think one final question, if I may, and I don't mind if Rhiannon and Jonathan, you could fight it out between you who answers this one. But what should I do if I'm not satisfied with the policy quotations the brokers provided? The best way to deal with that?
I think you've got to go to market, and basically you shouldn't just accept what the first quote. There are plenty of insurers out there and it's a competitive market, certainly so far as some covers are concerned. So I would definitely, if you're not happy with the quote, I would challenge the broker. I would want to understand the basis on which the quote was made, because I think, as I said before, it may be that if you put certain risk mitigation strategies in place, then the insurer will take a slightly different view, and therefore you might improve that quote. But at the same time, I would also look at obtaining some other competitive quotes to see if there is a better deal. You don't necessarily want the cheapest one; you want the one that's actually going to provide you with the cover that you actually want to cover your key risks, and so you can sleep soundly at night. So always be challenging.
That's really helpful. Thank you ever so much. Well, we've gone through all of the questions that we've got today. As I say, this session's been recorded for those of us who want to revisit it later, and I'm sure that both Jonathan and Rhiannon would be happy to answer any questions if you come up with anything at a later date. We'll circulate this recording to everybody today, so you'll have that for future reference. And as I say, do drop us a line if you do have any queries in relation to the issues that we discussed today, or more generally in relation to insurance risk and regulatory. I know Jonathan and Rhiannon will be delighted to assist you. But for the time being, thank you for joining us today. We hope you found it useful. If you have any ideas for future sessions, then do drop us a line. But until then, we'll see you soon. Thank you. Goodbye for now.